Okay, hello everyone. So Kanchan and Neha, you guys are new students or you were there in Constitution also?
Ma'am, I am new. Just joined a week back.
Am I audible? Am I audible, everyone?
Yes, yes.
Okay. So you were there in Constitution also, or new students?
No, I wasn't there in Constitution.
I can't hear you.
Yes, ma'am.
Yeah, like you were there in Constitution also, or you have like recently joined?
So at the last moment, I have.
Yeah, last
joined.
moment you were there. Yeah. So I can't hear what Neha was saying. Okay, fine. Okay, so today we'll start with contract, okay? Indian Contract Act 1872. So I will just share one screen with you. Okay, so we'll start with Indian Contract Act. Anyone can tell which year it came? Contract Act. Indian Contract Act of which year? Okay. So now for Indian Contract Act 1872, so this part is included for only like your prelims part, okay? It's not there in mains. So what happens is that for Indian Contract Act, you don't need to like study in detail like what we did for Constitution, right? For contract, what we need to do is that basically for like prelims thing, right? They are asking basically from sections that what is it that this particular section is talking about, or under which section the word contract is defined, or things like that. So it becomes like a little more easy when a subject is only there in your prelims and not in your mains. So for Indian Contract Act, what you need to study basically is that you need to be clear with the sections. They are mainly asking for sections only, right? That for definition part, if you see that which section defines this particular word, or section 11 is talking about what, section 10 is talking about what. So having an understanding of the sections, that would help you, right, in answering your questions. And also what we will do is that while discussing like individual topics, right, take for example offer, what is a general offer, what is a specific offer, or things like that. Just for a better understanding, we will also look at some of the like landmark case laws also, but case laws and all that much in detail, maybe it's not necessary from exam point of view, but it would help you understand the concept. When we are talking about specific contract, take for example, if you read 2-3 cases along with that, it would help you understand the concept better. So we will see few cases also, and also the topics, but main thing that you should focus on is that they are asking from like sections only. If you look at previous year questions also, mainly from sections, so that part you should focus on, and along with that you should also understand the important topics and also some important case laws that you should obviously know for this subject as well. So anyone knows about the history of Indian Contract Act? Where did we have any other law that was applicable there, like before Indian Contract Act 1872 came into picture? What were the rules that like basically governed contracts between two parties or two organizations or things like that? Anyone? Did we have anything before Indian Contract Act came into picture? Now see, for Indian Contract Act, right, we can say that initially what people used to do, there was this barter system was there, right? I would give you something and I will take something else in exchange of that, because we were not, like dealing in terms of money. So that also we can say that that also was like one type of contract, right? I would say that, okay, fine, I'm giving you like 5 kgs of rice and you give me like 5 coconut. So whatever people were having, based on that, like people were dealing with the other person, right? Whatever is my necessity, I will take that from you and I will give you something that you want. So basically what happened is that initially there were this barter system and all that, also we can say that also is one type of contract only, right? I'm giving you something, you give me something in return of that. So initially that thing was there. Then we were not having like a codified law, right? Like how we have now, Indian Contract Act, it's very well defined. If I want to make a contract with you, I know what should be there in that particular contract, how I should draft the contract and all the other details. But before that, there were no such, like a codified law or a codified provision. So what people used to do is that they would, like based on moral values, maybe like word of mouth only, they had to enter into an agreement with someone else, right? If I'm saying that, okay, fine, today you give me like 5 coconuts, tomorrow I will give you 5 kgs of rice. Now there is no like, like in a written format, I have not signed it, but it's just like a word of mouth only. Whatever I'm saying, you trust on me and so you would deal with me. So like that only things were going on. Then we were also having like other sources of like law that we see, right? Like the shruti smritis that we have seen, right? Sources of Hindu law. So from there also, whatever reference they could take, that part also they would take. If someone is saying that, okay, fine, like a like a dependent person cannot make a contract, so that part also we would take into picture, right? If I'm a dependent on of someone, okay, like take for example, I am a dependent of a person and that person is having like 5 plots of land. Now being a dependent, I have a right to enjoy that particular plot of land, right? I can stay there, I can enjoy those lands, but I cannot make a contract with you, right? I cannot sell that plot of land to you. Why? Because that is not my land. I am just a dependent of that particular person. So like that, maybe there are certain rules that, okay, fine, a dependent person cannot like make a contract, a person of unsound mind cannot make a contract. So whatever things were there in any of those earlier sources of law, that things also, like people would take into consideration and accordingly they would deal with the other parties. Similarly, we were having like some charters where charters used to be there, right, during British period. So there also some references used to be there. So wherever we would get some kind of reference, from there we would take that part. So basically we were not having like one single decided like a code of law, right? Wherever we are getting something, we are taking it from there. That means there are multiple sources from where we were taking like 1 or 2 principles, but we were not having one single thing or one single document that we can refer to if we want to enter into a contract with a certain person. So basically before this contract act came into force, we were not having like any such kind of a defined thing. Wherever we would get a reference of that, we would take that from that particular source or that particular thing, and accordingly we would deal with people. But then during British time only, there were certain law commissions. So second law commission basically recommended for the first time that we should have one like a uniform law that would be applicable for everyone, right? It should not be that, okay, fine, I'm knowing that this particular source of Hindu law is talking about this, so I would follow that. Maybe someone else is not knowing about it, that person would follow from somewhere else. So we were not having any sort of uniformity, right? So second law commission that recommended that we should have one uniform code that can be applied by everyone, so that it is same for all the people who are entering into a like a contract. And it was third law commission of British India that actually made a draft, and later on, after a lot of delay and everything, finally we have the Indian Contract Act 1872. So basically for Indian Contract Act, you can remember that before this act came, we were not having one single codified thing. Wherever we would get something, that part only we would take as a reference, that principle only we would apply, and things like that. finally this act came during British period, and we are following this act till now, with some here and there some minor changes that we have made just to satisfy our needs of the present time. So basically this act came in 1872. So again, now the history part is not that important. I'm just giving you for your reference. So history part is not that important from exam point of view, but there are two things that you should remember that is very important. It is these two dates. Okay, date of enactment and when it came into force. So what is the difference between these two dates? Why do we need like two different dates for one single legislation? What is the difference between date when it was enacted and when it came into force? Anyone? Am I audible? Like you can say any difference between the date when it was enacted and came into force?
I guess enactment is more at a draft mode where a legislation has been drafted and it undergoes a series of approvals at Lok Sabha and Rajya Sabha, and then after the approvals from both the houses of the parliament, it comes into force on that particular date. So that is why for one legislation we might have two different dates.
Okay. So now when a particular legislation is introduced, after that you are saying that there is like a series of approvals that we need, right? So when we are introducing it, that we can say that we are introducing this particular bill. So that is not an act till, like at that moment, that is not even an act. We are introducing that act. But take, for example, all those, like stages of approval and everything is being done. After that, what happens? Take, for example, now we are not having, like any legislation to deal with environment related issues, okay? Today we feel that we should bring one legislation that will protect our environment. So this bill is introduced in parliament, it passes all those stages of approval and everything. Today bill is enacted. Now what happens is that we would need certain, like organizations, maybe we would need certain different bodies to look into the matter, right? We cannot just say that, okay, fine, we will have like a national green tribunal that would look into environment related matters. We should have that in reality also, right? We should have that body. We should employ like officers and all the designated persons, their members and everything, so that they can function accordingly. They can perform their task that is being given to them. So what happens is that we cannot just say that, okay, fine, this is the legislation, it becomes applicable. We should also look into other some sort of formalities that would be there, right? So what happens is that enacted is like it's accepted, but we would take some time to make it applicable. Maybe there would be certain formalities. We need certain establishments of certain different officers to be appointed or other things. So came into force as it from this particular date, it will become applicable. We need to follow this particular thing. So for Indian Contract Act also, you need to remember these two different dates. And for that matter, whatever legislation you are studying, right? For judiciary, this is like a very common question that they would ask you when it was enacted, when it came into force. So whatever legislation you are studying, make sure to remember these two different dates along with the year. For some legislations, you would see year is also different. Maybe it would be like, or like towards end of 1871 it was enacted, but starting of 72 only it came into force. So date and year, both the things you should remember for whatever legislation you are studying, okay? So for Indian Contract Act also, it's very important for you to remember both these two different dates. So it was enacted on 25th of April 1872 and it came into force from 1st of September 1872. So year is same, just we need to remember two different dates, 25th of April and 1st of September. So is this part clear, like the history part? Nothing much to remember from that part, just these two dates. So is this part clear? Any doubts, anyone? Is this part clear?
Yes, ma'am.
So try to remember these two dates, okay? So here is same that you can remember 1st of September. So you can remember like we are starting this class in September month. So you can just remember 1st of September it came into force, it became applicable. We have started studying contracts, you can remember like that, and 25th of April that you should remember. So both the two dates are very important from this part. Now we will move with the main, like provisions under the Indian Contract Act. So what happened is that this act, right, this came during, like the British period only. Take for example, when this act came into force, maybe we were not having these many different types of contracts that we are having right now, right? So we would need certain different changes to be made in it. So there were some changes, like take for example, it was mentioned that, like if two parties are entering into a contract, right? If you and me are entering into a contract, we can make a clause where we would say that in case there is any kind of, like violation of this contract, any kind of dispute that arises, we would go to an arbitrator and not to the regular court. So those kind of things we can mention under the contract. So that is one change that is being made. Then there is also one provision that if my consent is being taken under, like by undue influence, it would become voidable. So minor changes are being made depending on the situation. Okay, that part is not that important, I'm just giving you for your reference. So what happens, take for example, you are a company, okay, you are a big company, you are making like thousands of contracts on a daily basis. So if there are like hundreds of disputes out of those thousands of contracts, if there are hundreds of disputes that arises out of those contracts and everyone is filing a case in the regular court, so what you cannot do is that every single day you cannot be visiting the court, right? You also need to look into your day-to-day functioning of the company. So it is very important that people or like entities are being given this flexibility that they can mention a clause that in case any sort of dispute arises, we would approach an arbitrator to settle the matter. Maybe we would compensate to the losing party depending on whatever order is being passed or things like that. So this is just to make it more easier or more simpler for people to enter into different types of contracts. So these are some minor changes that are being made under the Indian Contract Act depending on the situation. So this thing was inserted after the Arbitration and Conciliation Act came. It was like 1996. So that time this part was inserted. Now for Indian Contract Act, it had these like 4 different parts. Okay. So Indian Contract Act was having 4 different parts. What is the first part? It is general principles of law of contract that is mentioned under sections 1 to section 75. So what are these general principles of law of contract? Any example that you can give? What things are included in this first part, sections 1 to 75? Anyone? Sections 1 to 75. It is talking about general principles, right? So what sort of general principles are there?
Ma'am, like offer and all, like, valid contract, offer, acceptance, promise, like that.
Yeah. So when we say general principles, it means that these would be certain general principles that will be applicable to any type of contract that we are making, right? So it is not specific to for what purpose we are entering into the contract or what would be the duration, what would be the type of contract or anything like that. These are some general principles that are applicable to any sort of contract. So maybe today we are having like, take for example, we are having like 50 different types of contracts. Tomorrow or after 1 or 2 years, we also have like 20 other different types of contracts. Now what happens is that these general principles are such that those would be applicable to these 20 different, like these 20 new types of contracts also. Basically, these are like universally applicable, right? Who can enter into a contract, how we need to make an offer, how the other person will accept it, and all of that thing, right? Basically, how these entire, like the system or entire the process of framing a contract would go on, right? So these are general principles that will be applicable to any kind of contract, no matter for what purpose you are entering into the contract, or whether it's between two parties, more parties, what is the type of contract or any such thing, right? So these are certain general principles applicable to any kind of contract that two or more parties have entered into. So these general principles part we need to study, where we would study about the essentials and all of that part, right? What are the essentials of formation of contract and all of that. Second part is sections 124 to 234. That is talking about certain specific types of contracts. So what is specific types of contracts? Specific types of contracts. What are these contracts? Anyone? Specific types of contracts?
They are made for a specific purpose, and the purpose is ascertained and defined.
Yeah, so they are made for a specific purpose. Now, what happens is that maybe I want to make a certain contract and for this specific purpose only. When I know this specific purpose, based on the purpose, I can, classify that contract basically, right? So whatever specific types of contracts are mentioned under it, it is divided based on the purpose of entering into the contract, right? What is the main purpose that these two parties have entered into this particular contract? And depending on that only, we would classify it. So under Indian Contract Act also, there are different types of specific contracts that it mentions. It mentions regarding indemnity, guarantee, bailment, agency, pledge. So these are what, depending on for what purpose the parties have entered into the contract, they are making it, right? So we will also study, what is the difference between a contract of indemnity, guarantee, bailment, agency, pledge, and all of that. And what would be the, rights and obligations. Now, in general, also we are having certain rights and obligations, right? If I'm making a, if I'm making a contract, forming a contract with you, I would have certain obligations. You also will have certain obligations. But in case of these specific contracts, maybe our obligations would also be of a certain, certain type or a certain nature. So those things also we need to, study. What would be the rights and obligations in a contract of bailment and things like that. So that part also we would study in the second portion, okay? That specific types of contract. What are these specific types of contract, how they are different from one another, and what are the rights and obligations of the contracting party. So these two parts we will discuss. So what about the remaining sections, like from section 76 to 123? What about those sections? What about those sections in between? Anyone? What about the remaining sections? So we have certain general principles and also we have some specific types of contracts. Now, what about these remaining sections in between section 76 to 123?
Bhaiya.
Anyone? So if you see here, what happens is that section 76 to 123, right? These provisions were a part of Indian Contract Act until the year 1930, right? Until this year, what happened is that these sections were dealing with provisions relating to sale of goods. So with regard to sale of goods, these provisions were, making specific provisions. But after that, what happened is that we had a separate legislation. It is called the Sales of Goods Act. Sale of Goods Act. That means for Sale of Goods Act, rather than having some provisions under the Indian Contract Act, we had a different legislation altogether. So this particular part was repealed. Okay, so we don't need to study these sections. section 76 to 123, this part was repealed from the Indian Contract Act, and we have a different legislation, Sale of Goods Act 1930. I think this part was removed from judiciary syllabus. Like previously it was a part of judiciary, I guess, Sale of Goods and Partnership. Now they have removed it and inserted NI Act and Specific Relief Act, if I'm not wrong, right? Or is this still a part of any particular state judiciary? Anyone?
Ma'am, for objective it is not there, but I think for subjective it is there, ma'am.
Okay. Okay, for some states maybe it's there, but I guess for Karnataka they have removed. I'm not very sure, but yeah. So for sale of goods, we have a different legislation, and that part is being repealed. But after this section, right, 234 also, there were certain 123, right? Sorry, 234, right? There were also different say. So after this section also, right, 238, after this also, there were certain different sections that were there under the Indian Contract Act. So what happens is that, yeah, so there were also certain different provisions that were there under the Indian Contract Act. Now what happened to those provisions is that these provisions were basically relating to partnership. So these provisions were basically with regard to partnership, okay? And these provisions were applicable only till the year 1932. In 1932, again, what happened is that these sections were removed, right? These were repealed from the Indian Contract Act. So again, we don't need to study these sections because they were repealed from the Indian Contract Act, and we have a different legislation for partnership as well. So it is Partnership Act of 1932 that we are having. So again, partnership also, I'm not sure for which all states they have included, but yeah, it's also a different portion. So what we need to study now for Indian Contract Act is only these two parts, right? Sections 1 to 75, that is talking about the general principles of law of contract. These are the basic principles that we need to follow for formation of a valid contract, right? That the object of a contract should be valid, the consideration should be valid, and all of that. All the things should be valid for formation of a valid contract that we can enforce in the court of law. And for specific types of contracts, we have these different types of contracts that we need to study, like indemnity, guarantee, bailment, pledge, agency, etc. But it's not like only these are the specific types of contracts that we are having, right? There are multiple other types of contracts for which, for some of them, we are having like different legislations also. For some, maybe we are not having legislation, but by following these general principles only, every single day people are entering into different types of contracts, right? Take for example, a service level agreement that a person makes, right? I'm providing a certain type of service to another person, right? Take for example, I'm writing content for a certain company. There is a contract between me and that particular company. We do not have a legislation for that, like a certain service level contract, but we are following those general principles, and then we are forming a certain contract, and then we are accordingly like dealing with that particular part. So there may be certain different types of contracts for which what we are not having is that we are not having maybe any specific legislation, or maybe Indian Contract Act is not specifically talking about it, but even then we can make that contract. How? By following those general principles. So basically these general principles are something that gives us a clear idea as to how we can make a contract no matter for what purpose we are entering into that particular contract or other things. So these are the main things that we need to study. So basically this part, you know, like syllabus for Indian Contract Act has become like very short, right? Only 2 different parts are there that we need to study. Sections 1 to 75 and then 124 to 238. Again, from this part also, not like all the sections are very important for you or something like that. We would study whatever is important, or we will also discuss some like previous year questions and all of that. Like basically MCQs only. We will try to see what kind of questions they are asking, and based on that we will prepare for this. So is this part clear? Any doubts till this part? Any doubts in this part? You want any part to be repeated or something? Anyone? If you have any doubts or anything, you can tell me if any part is to be repeated or something. See, if you are silent, I won't understand, right? If you are understanding or not. So you can tell me clearly. Is this part clear?
Yes, ma'am.
Okay.
Yes, ma'am.
So now what we need to study, we know, right? That we need to study these general principles, and also we need to study the specific types of contracts. Now what happens is that, see, like for judiciary also, if you are preparing, right, you would have like 8 to 10 different subjects. Now you cannot follow the same you know, like strategy for all the different subjects, right? Take for example, certain subjects are included for your mains. How you need to prepare for that? You need to prepare each and every like important topics. You need to study those in detail or things like that. But if a certain subject is inserted only for your prelims part, you should follow a different strategy for that, right? So you cannot waste your time reading something that is not important from exam point of view, right? So for contract, what you can do is that your main focus should be on remembering the important sections and also the important provisions. It's not very important for you to know. Take for example, there is any concept like you know, like communication of offer or something like that. So it's not very important to read, for you to read like an entire, you know, like big article, knowing about its, you know, like what is the good thing about it, bad thing about it, and all of that. What you need to study is that for, you know, like how questions are being asked. Based on that only you need to study. If they are asking from sections part, you would study sections. If they are asking like conceptual things like from communication also, if they are asking when communication is complete, when it is not completed, or things like that, then you need to have an understanding of those things. Okay, so you should not waste your time, you know, like unnecessarily studying in depth about a certain you know, like a certain topic. So whatever is important, accordingly you should be preparing for it, so that you can you know, like cover most of it. Because even though like 2 parts are been, you know, like repealed from it, still we have a lot of sections, right? So whatever is important, accordingly we should be studying that, so that we can answer most of the questions in you know, like exam. So accordingly we will see how they are asking questions and all of that. Now there is this table. Okay, this is about the provisions under Indian Contract Act. So whatever part is there, whatever part we will be studying, for that we are having this particular table. So now what you can do for this particular part, right? If you are very good at remembering sections or something, what you can do is that you can remember, like have an understanding that, okay, fine, sections 1 and section 2 is talking about scope and definition. That is like very common for most of the legislations anyways. Sections 3 to 9 is talking about communication regarding acceptance and revocation. 10 to 30 is with regard to voidable contract, void agreements. So if you remember like this also, right, that also would help you a lot in answering your questions. Take for example, one question comes with regard to contingent contract. Which section defines contingent contract, or which section is mentioning provision regarding contingent contract? What sections they have given is that one section is something in between sections 31 to 36, and other options that you have are, take for example, section 29 they have given, section like 27, 25, 26, something they have given. So even if you do not know the exact section that is talking about contingent contract, if you know that, okay, fine, it is something in between like 31 to 36, that also would give you a clear idea to answer questions in most of the cases. So even if you cannot remember a lot of sections, try to at least remember this particular part, that okay, fine, sections 1 to 2, scope and definition, 3 to 9, it's about communication, acceptance, revocation, etc. So like this also, if you remember, right, that also is going to be very helpful for you. So you can just go through this particular table that is in short mentioning what all these like different chapters that are talking about. So basically we are having like 9 different chapters and also a preliminary part, because these 2 different chapters are being repealed. We don't need to study that. So other things we will be studying accordingly. So for this, whatever part is important and things like that, we will study that part accordingly. So you can just go through this particular, like list and try to remember, if you can, whatever sections you can try to remember that part also, which will be very helpful for you to answer the questions. Okay. So now another important thing that we have is with regard to scope and definition. Okay, so can anyone tell what is the scope of Indian Contract Act? To where is it applicable? Scope of Indian Contract Act.
Whole of India?
It is applicable to whole of India. So is it applicable to Jammu and Kashmir and Ladakh?
Yes.
Yeah, so it is applicable to Jammu and Kashmir and Ladakh also. But now if you open your BEAR Act, right? If you open your BEAR Act and see like section 1, you would still see it is written like that only, that whole of India except the state of Jammu and Kashmir. So why is it so? Why is it not being removed? If you open the BEAR Act, it is still Jammu and Kashmir is like excluded from that part, right? Why is it so? Anyone having the BEAR Act of Indian Contract Act? Anyone having BEAR Act with you?
No, ma'am.
No, we don't have that. I don't have that.
Ma'am,
You have.
what do you want me to see, ma'am?
So what is mentioned in like section 1, scope of the act, with regard to scope of this act, where is it applicable?
Just 1 minute, ma'am. I'll just check. Except Jammu and Kashmir, ma'am, it says.
Yeah, so is it applicable to Jammu and Kashmir or not then?
Now, as they have become union territory, I'm not very sure, ma'am, that
Okay.
whether it will be applicable from now.
Okay, so see, for most of the legislations, right, whenever we are reading it, even now, if you see most of the legislations, they would mention that it is applicable for whole of India except the state of Jammu and Kashmir. Now, we are also confused. Is it applicable to Jammu and Kashmir or not? Because it's no more like a special state, right? So whether it's applicable or not to the state of Jammu and Kashmir. So in any case or in any situation, if you are reading a particular legislation and you are not sure whether it's applicable to the state of Jammu and Kashmir or not, there is one like very simple solution that you can take that will help you understand if it's applicable to Jammu and Kashmir or is it not applicable. So what is it? You can refer to one legislation. This legislation is So I will also give you a link for this legislation. This legislation is the Jammu and Kashmir Reorganization Act of 2019. Okay, so this is
So ma'am, now on it is applicable for J&K and Ladakh, ma'am?
Yeah, it is applicable. So in any case, you are reading a legislation and you are not sure whether it's applicable or not, you can just refer to this particular legislation. Okay, in this legislation there are like two different schedules where they have mentioned what all legislations will now be applicable to the state of Jammu and Kashmir and what all were not applicable like previously, right? So if you look at this particular legislation, you will see that previously for the state of Jammu and Kashmir, what happened is that we were having a different legislation, right? It was called the Jammu and Kashmir Contract Act 1977. But now what they have done is that rather than changing, because there are like thousands of legislations that we have, right? So for all the legislations, they cannot be, like making those small changes, right? That except the state of Jammu and Kashmir part, they would just, like strike out or things like that. It would be unnecessary task. So what they have basically done is that in this Jammu and Kashmir Reorganization Act, they have basically mentioned like a big list of all the legislations which all would now be applicable to Jammu and Kashmir and also Ladakh. So what they have done is that they have mentioned that from Indian Contract Act 1872, what we are doing is that we are omitting this particular part that was mentioning except the state of Jammu and Kashmir. So now this part is being omitted under this particular legislation. So even if you look at the, like bare act of Indian Contract Act, you would still see that part is being mentioned, but it is no more valid. Why? Because that part is being removed under this Jammu and Kashmir Reorganization Act. So whatever legislation you are reading, just refer to this particular legislation. Just type it there, you would get it. Indian Penal Code, you would see there was a different, like a different legislation in case of Jammu and Kashmir also, right? What was the name? Anyone remembers? Penal Code for Jammu and Kashmir? It was Ranbir Penal Code. Okay, so name is also funny. State Ranbir Penal Code 1989. So that was the legislation that was applicable in Jammu and Kashmir. Now that is also being repealed. Indian Penal Code is being applied. So like that, whatever legislation you are reading, you can refer to this particular act. If it is mentioned, then it would be applicable to state of Jammu and Kashmir also.
Ma'am, so
Yeah.
as of now, except the land laws, I think as Jammu and Kashmir has become an union territory, so now even like, all the laws, like, there can be a trick question in MCQs which can be asked that, what is the scope of that. So as of now, all the acts of India will be applicable to Jammu and Kashmir except the land laws.
See, we cannot say all the laws of India because there may be, like certain central laws which are not applicable to all the different states, right? There can be like AFSPA and all are not applicable to entire, like all the states or all the union territories of India.
Yeah, like I want to ask the common laws, like, Constitution, IPC, contract.
Yeah, most of the common laws are applicable. There may be some like hardly few examples where it may not be applicable. Again, they might be having certain different things, right? For basically it would be for land laws and all the other things where, like municipal laws and all where the state is basically making their laws. For that, it would not be, but otherwise most of the general things are applicable. It's like a big list of legislations that you would see. So most of the things are made applicable in Jammu and Kashmir also.
Okay, ma'am.
Yeah. So for the scope part, it is now applicable to the whole of India, including Jammu and Kashmir and Ladakh also. Okay, now next part is, so you can go through this particular list, okay, what all sections are talking about what things, and you can try to remember this thing so that if a question comes with regard to bailment, at least you have an idea that, okay, fine, it is somewhere in these sections only that it is talking about. So if they have given one section from this particular portion and other sections from like agency or, like indemnity or other parts, you at least have an idea, right? Because that time though it would be like a very simple question, right? So that time at least you would be able to answer this. So you should try to, like go through this particular list so that you have an idea on what all things are covered on which all things. Now, another part that is important is with regard to the section, like definitions. So section 2 of this particular act is providing for different types of definitions. So Mansi, you are having a bare act, right? How many definitions are given under this legislation? Section 2.
1 minute, ma'am. I'll just. Ma'am, till subsection J, I can see.
Yeah, till subsection J. That means there are 10 different definitions given. So how
Not
easy?
definitions, ma'am. Under section 2, you said, right, ma'am?
Yeah, section 2.
It talks about interpretation clause.
Yeah, interpretation is definition only, basically.
Yeah, but ma'am, like other laws, they used to say, like who are the person and all. So all are not like that, but the last is J, which says that a contract which ceases to be enforceable by law become void when it ceases to be enforceable. So it's still J.
Yeah, till J. So these only you can consider as definition only, right? Basically, they are defining what is a contract, right? That contract is what? Something that we can enforce in the law and things like that. So these you can consider as definition only. Basically, they are interpreting what this particular term would mean under this legislation, right? So if they are saying contract could mean something that is enforceable under law, that we can say that they are trying to define what is the meaning of the term contract under this legislation. So we can in a way say that there are 10 different sections that, like 10 different definitions that are given under this particular legislation. So how easy is it for you to, like remember this particular thing, like which, like which section defines which term, because that is like very important part from where questions are mostly asked, right? Which section defines contract, which section define void agreement or things like that. So how easy or difficult is it for you to remember that part? Anyone remembers all the different, like sections that provides for the definition of different terms or things?
Yes, ma'am. Like more or less, yes.
You
Like
remember?
the basic is like promise, promisee, then consideration, agreement, voidable contract, void contract. Yes, ma'am.
Yeah. So now what happens is that mostly they are asking questions like which section defines consideration. So you need to know that, okay, fine, it is section 2D. Now, like the questions of judiciary are a little different from the questions that we used to have in our LL.B, right? In LL.B, what we had to do is that we had to even remember the definition, right? For contract, they would say like define contract, right? So what we need to do is that we would have to write the entire definition that is being given under a legislation, or maybe by different, different writers or things like that, right? We had to remember a lot of definition, right? Even for jurisprudence, define ownership, define possession or things like that. But here what they are saying is that basically they are asking which section is it that is defining consideration. So what we need to remember is that we need to remember it is section 2D of the Indian Contract Act that is defining the term consideration. Maybe we don't need to remember the entire thing word by word what consideration is, but we should have an understanding that, okay, fine, this is what is consideration. So like that, we should be studying this part. So it's very good if it is easy for you to remember all these, like 10 different definitions, right? The 10 different sections that is defining 10 different words. It's very good if you can remember that part, because that is something very important from where questions are being asked. If you cannot remember this part, then you can follow this one like easy trick, okay, that I just tried. So I just tried to remember all these, like different sections following like one simple, like one simple thing, keeping one simple thing in mind. I just tried to remember. So Mansi, can you check if I can, see it like in a proper sequence, all the different definitions?
Okay, ma'am.
Okay, I will be saying the words. You can just see whether I'm saying it in the proper sequence. Okay, so first is your proposal.
Yes, ma'am.
Then acceptance or promise.
Yes, ma'am.
Then you're like two different parties, promisor and promisee.
Yes, ma'am.
Then is consideration.
Yes, ma'am.
Then we have agreement.
Yes, ma'am.
Reciprocal promise.
Yes, ma'am.
Void.
Yes, ma'am.
Contract.
Yes, ma'am.
Voidable contract.
Yes, ma'am.
Becomes void.
Yes, ma'am.
Okay, so see, how did I remember this? So it's what happens is that sometimes we may feel that, okay, fine, there is one definition called void, another definition called which becomes void. So it may be a little difficult to remember in a proper sequence, right? So if you can remember it, only 10 definitions, right? So if you can remember, okay, fine, first is promise, that means it is section 2A. Consideration is what? Okay, consideration is coming at 4, that means it is section 2D. So like that you can remember. So how did I remember this part is basically I tried to remember this particular, like a conversation kind of a thing that you can also try to remember. It will help you remember all the different definitions. So I already told you, right? Entire definition you need not know word by word. You just need to have an understanding, and also which section is defining what word, okay, for judiciary. So now you can remember this particular situation, and it will help you remember all the 10 different sections accordingly. Okay, I just wrote this like yesterday. So I just tried to test it whether it's working for me or not. So if it's working for me, I'm sure it would work for you also. So what is this situation firstly? First, take for example, I am asking you something, okay? What am I asking you? I am asking you, would you like to study the Indian Contract Act 1872 from me if I also provide you some important MCQs of it? That means I am asking you if you would like to study Indian Contract Act. What I will do is that apart from teaching you Indian Contract Act, I will also discuss some important MCQs relating to that part, okay? So what am I doing here?
Asking. Or
Asking. Yeah, so what it will
proposing
be?
something.
Yeah, I'm proposing something, right? So what I'm doing here is I'm giving you a proposal or an offer, right? So accordingly, you can read the, like definition. Mansi, can you read it for me? Like section 2A, what is it that is defining?
Yes, ma'am. It says that when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such other or subsistence, he is said to make a proposal.
Yeah. So it is providing for a definition, right? Providing for a definition of the term proposal. What it is saying, if others are also having a Barrett, it would be easier for you. Even if you don't have, you can just open it on your phone. It would help you understand the definition easily. So it is section 2A that is defining what? That is defining a proposal or an offer. What is proposal? When one person signifies his willingness to another. That means I'm telling you about my willingness. What is my willingness? I want to teach you Indian Contract Act, right? So what I am doing here is I am telling you my willingness that I want to teach you Indian Contract Act. Why am I telling you this thing? Because I want to obtain your assent there too, right? I want to take your consent also. It's not enough that I want to teach you Indian Contract Act, right? You should also be willing to learn it. So what happens is that I am letting you know about my willingness just in order to get your, like your acceptance or your approval or your, like just to know what you think about it, right? So I'm telling you that particular thing. He is said to make a proposal. That means I'm making a proposal. What I'm doing, I'm asking you, if I teach you Indian Contract Act and also discuss this MCQs, would you like to learn it from me? So what I'm doing here is I'm making a proposal or an offer. Okay, so this first definition is clear, right? What is proposal? I am signifying my willingness. I am letting you know about my willingness to do or to abstain from doing something. That I want to teach you Contract Act, or maybe I want to abstain from doing something. Why am I letting you know about this? Because I want to get approval from you also, right? Because it's not enough that I want to teach you Indian Contract Act. You should also be equally interested in learning it from me. So I'm telling you just to know what you think about this particular proposal or offer. So this is the first definition that we have, okay? It is with regard to offer or proposal. Now, second thing that we have is, so this first definition, is it clear? Offer or proposal?
Yes, ma'am.
Okay, so what is the second thing? You are saying, okay, I don't mind learning it from you, but only if you provide the MCQ. So I had mentioned like two things that I would discuss it also. 1 second, huh? Hello? Oh, ma'am. Okay, so first thing is clear, right? That I'm making a proposal or an offer. Now, what is the second thing? And in that particular proposal or offer, I mentioned two different conditions, right? I will be teaching contract act and also I will be discussing MCQs. Secondly, what you are saying is that, okay, I don't mind learning it from you, but only if you provide MCQs. That means you are accepting to it, and also that I should follow both the two conditions. Okay, so what is it that you are doing? Second part,
Accepting.
you are accepting this particular thing, right? That you are accepting if I'm fulfilling the condition. So what is the definition given for acceptance? Section 2B.
When the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise.
Yeah, so when it is accepted, it becomes a promise. So what is acceptance? When a person to whom proposal is made, right? So I was making the proposal to you that I want to teach you Indian Contract Act and also discuss the MCQs. So who can give acceptance? You can give acceptance, right? So when the person to whom proposal is made, I was making the proposal to you. So you have this right to decide, right? You can give your assent there too. So if you are giving your assent or if you are giving your approval to that, then it is said that it is accepted by you, right? So when you are saying that, okay, fine, I can learn Indian Contract Act from you, that means you are accepting, you are giving your acceptance. Now, when I'm making an offer and you are accepting that particular offer, what it becomes? It becomes a promise, right? Two of us have agreed to the particular thing. So section 2B is defining acceptance also, and it is defining promise also. So is this definition clear? Acceptance and promise?
Yes, ma'am.
Okay, so this is the second thing, right? That we have. Thirdly, I and you agreed. So what is it? I means I'm the, who am I here?
Promiser.
I'm the promiser, right? Because I'm making the, like proposal. So, and who are you?
Promisee.
You are the promisee. So section 2C is defining the parties to the contract. So the person who is making the proposal is a promiser, right? I am making the proposal, so I am the promiser, and you are accepting to it. That means you are the promisee. So third thing, it is I and you, not you and I. You can remember like this, that so that you can remember that, okay, fine. First it is defining promiser, second it is defining promisee. I means who? I'm the person who is giving the promise, making the promise. That means whoever is making the promise is a promiser. You are the one who is accepting it. That means whoever is giving his acceptance, that person becomes a promisee. So section 2C is providing for definition of parties to a contract. Now next is, I want to teach to get teaching experience, and you want to learn to maybe get a better understanding, or maybe, like
it's 8 o'clock.
To prepare for, to prepare for your judiciary. So what is the fourth thing? I want to teach you. Why do I want to teach you? Because I want to gain some experience. Why do you want to learn? Maybe you want to prepare better for your exam. So what is this particular thing? Say, fourth thing. Fourth thing, what is this?
Consideration.
Yeah, fourth thing is what? It is consideration. So what is the definition of consideration that is being given under the Act? Definition of consideration.
Yeah, sorry, ma'am, it was mute.
Yeah.
Yeah. So 2D says that when at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something, such act or abstinence or promise is called a consideration for the promise.
Yeah, so consideration, we will anyways discuss this, like definition later on in more detailed way. So what is consideration? Consideration is basically something for which we are, like fulfilling our part of contract. So what is consideration? Consideration is something for which we are performing the contract, right? For me, consideration may be that I want to gain some experience. For you, consideration may be that you want to maybe prepare better for your exams, right? So what is it that is, like allowing both of us to, like perform our part. Why am I willing to, like teach you? Because I want to gain some experience. Why did you agree to learn it from me? Because you want to prepare better for your exams, right? So what is consideration? Consideration basically is something that would, like for which we would basically do our part of contract, right? So you can remember it accordingly. So section 2D is talking about consideration, that I want to gain some experience, so I am teaching. You want to prepare better for your exam, so you are learning. So basically both of us are getting something because of which we are performing our part of contract, that I am teaching, you are attending the class, right? So that is what consideration, it is defined under section 2D of the Indian Contract Act. Next is both of us agreed both of us agreed thinking about the benefits. So now both of us agreed thinking about the benefits. So what is it? Both of us agreed. That means what? It is an agreement, right? So next definition that we have is with regard to agreement. So both of us agreed. That means it's an agreement, right? So what is an agreement? Every promise and every set of promises forming consideration for each other is agreement. That means whatever single promise or, like group of promises that we have made, if there is consideration for both of us, then it would become an agreement. Consideration should be there so that we are, like also interested in performing our part of contract, right? So in this case, what it is a set of promises, right? I am teaching you Indian Contract Act, and also I'm discussing some MCQs. That means it's a part, like a set of promises, right? There are two different promises that are there. So then it would become what? Then it will become a promise. Both the persons have like agreement. Both the persons have agreed to something. So next definition that we have is with regard to agreement. Next thing is discussing MCQs is something that is also important here. So what is the main promise? That is teaching contract. But also I have agreed to discuss MCQs. That is also something important, right? Some important part of the contract only. So what is it? It is reciprocal promise, right? That means along with the main thing, I am also making some other promise. So reciprocal promise is defined under section 2F. What is it? It is promises which form consideration or part of consideration for each other is called reciprocal promise. Along with it, some other things are also there. That is section 2F of the Indian Contract Act. Now next is, if I do not discuss the MCQs, you will not continue with the classes. So what is it in terms of contract? If I'm, yeah, it is void, right? So what you will do is that you will not, like attend the classes. That means it becomes void, right? Discussing MCQs is also important. And if I do not do it, you will not continue with. So next definition that we have is void. An agreement not enforceable by law is said to be void. If I am promising that I will discuss MCQs and I am not doing it, so you discontinue, like you decide not to continue with your classes, then I cannot ask you to continue. Why? Because I am not fulfilling my part of the contract. I told you I will discuss MCQs, I am not doing it. That means I cannot enforce the contract. Why? Because I was not fulfilling my part of contract, right? So it is void. I cannot enforce it. Why I cannot enforce it? Because I was not performing my part, or whatever the case may be. So next definition that we have is void. Next is, only if I'm teaching and also discussing MCQs, I can ask you to attend the classes. So what is it?
Like enforcing the contract, like,
yeah, it is enforcing the contract, right? So I'm discussing the MCQs also, I'm teaching contract also. So now what I can do is that I can ask you to attend the class. That means I can enforce it, right? If you are not performing your part, I can enforce it. When I can enforce it, it becomes what? It becomes a contract. So section 2H is defining what a contract is. What is a contract? When I can enforce it, right? So an agreement enforceable by law is a contract. I am performing my part, so I can ask you to attend the classes. So it is section 2H that is defining the term contract. Next is, you have the option to leave the class in between if I do not discuss MCQs. What is it? You have the option, I don't have the option.
Voidable contract.
Yeah, voidable. In case of voidable, what happens is that one person is having this right that he can decide whether he wants to proceed with the agreement or not, right? So here, what option you have? You have this option to leave the class in between, but I don't have the option to leave the class in between. That means one of the parties is having this, like right to decide whether they want to continue or carry forward with that contract or not. So that means it is a voidable contract, right? One person is having this option. So it is section 2I that is defining what is voidable. Last is contract act is removed from judiciary syllabus. So from judiciary syllabus only this part is removed. Now what happens if judiciary syllabus only it is removed and you are preparing for judiciary, then what you will do? You will obviously not study from me, right? So what it becomes?
Void.
It later on becomes void, right? So at the moment, so it is the difference, right? Section 2Z is about void when it is not enforceable, that I am not performing my part of contract or whatever it may be, it is void. Second is something it later on becomes void. So a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. That means until the time contract act was part of judiciary syllabus, I would have asked you that, okay, fine, you please attend the classes. But if it's no more a part of judiciary syllabus, I cannot ask you to do that, right? That means it later on becomes void. So you can try to remember these, different sections that are defining different terms. It's well and good if you can remember like simply, okay, fine, section 2A is proposal and like that. If not, you can try to remember the simple, like a simple situation. It will help you, remember the thing. So firstly, I'm asking you, would you be interested to learn Indian Contract Act and also discuss MCQs? You said, okay, fine, I'm interested, but only if you do both the things. I and you both agreed. I want to discuss to gain experience. You want to learn just to, prepare better for your exams. Both of us agreed thinking about the benefits. Agreed means agreement. Discussing MCQs is something which is also very important here. If I do not discuss MCQs, you will discontinue. Only if I am teaching and discussing MCQs, I can ask you to attend the classes, and you have the option to leave the classes between. If I do not discuss MCQs, Contract Act is removed from judiciary syllabus. In that case, I cannot ask you to attend the classes. So if you cannot remember it serially, you can try to remember this particular situation. Like in a sequence, you should be able to remember all the different definitions that are being given. So any definition is not clear. Anyways, whatever is important, we will discuss that part later on also, like proposal, consideration and all we will discuss again. So any doubts on this particular part?
Ma'am, I don't have doubt on the section, but I have one concern actually.
Yeah.
I was solving few question papers, so there was certain MCQ which gave a example. Okay, like any situation it has given. For example, we'll take the thing which you said, like only if you are teaching or only discussing MCQ, I can ask you to attend the classes. So ma'am, now we know that this is a voidable contract, but in examination there are certain option which says about 4 things. First is void, then valid, then legal and illegal. So it is very confusing. So I just want to know if you can little bit clarify that in which sense we can say it's a valid or it's a void, or when we can use the terms illegal and legal, because it's very confusing when we solve that.
Yeah. So anyways, we are having this part, right? When we are discussing general principles of law of contract, we are having the essentials, right? That when a contract becomes specifically void, when a contract becomes voidable, all that part is there that I will discuss in detail. So I am saying that these definitions, right? Whatever part is important, that we are anyways going to discuss in detail in the elements when we are discussing like these things, right? So first of all, what we will discuss is that, see, for elements, right? I have this part also. For elements, when we are discussing, right, we will discuss in detail about all these different definitions and all. And also, I will clear that part. So there are certain contracts which are mentioned as specifically void. Certain things where object or consideration is not valid, that would be an illegal thing. So like that, you would be able to differentiate. So that part we will anyways discuss in the coming classes.
Okay.
Yeah. So for now, these are the definitions. So you can try to remember this part. What is a proposal? This is the, like complete sequence. That section 2A is talking about proposal, then acceptance and promise, promisor, promisee, consideration, agreement, reciprocal promises, void contract, voidable contract, and when it becomes void. Now, this part you should remember. Who is a promisor and promisee? That part you should not be confused, because when we are discussing something like later on, that when communication of offer is like completed or things like that, that time you should not be confused with who is a promisor and who is a promisee. So try to remember these two words, who is a promisor and who is a promisee, so that it helps you understand the remaining concepts that we will be discussing. Okay, now there is the like these three different things that we have. These are like three important definitions again that we will study. So any okay, so first is section 2E of the Indian Contract Act, which defines an agreement. What is an agreement? Every promise and every set of promises forming consideration for each other is an agreement. Next is void agreement and contract. So anyone, can you tell what is the difference between an agreement and a contract? Difference between agreement and contract?
Ma'am, I think when any agreement which is already enforced, we can say that will be a contract, and an agreement will be something like, certain terms and condition of a contract can be told as agreement. For example, if you are telling me you are making a promise, and if I am accepting it, so like, it can be like we can agree on certain point and we can later on disagree on certain point. So that can be agreement. But and there is also saying that, all agreements are contract, but all contracts, no, I think I'm wrong.
Yeah, you are right. Only all contracts are agreements, but all agreements are not.
Agreements are not contracts.
Yeah.
Yeah, that's all.
Yeah. So any example that you can give of one agreement and one contract? Simple example. One, like two different situations where one is a contract and one is an agreement.
Ma'am, for example, I have given a proposal that, you give me 2 cows, then I'll pay you 5,000 rupees. So this can be an agreement. So between you and me. So when I am giving you a cow and when you have paid me money, when the agreement is enforced already, so I think that will be a valid contract between you and me.
Okay. So see, when it is enforced, that means contract is only enforced, right? When I buy cow and I give you the money, that means the contract itself is enforced. Now, what is the difference between contract and agreement? You will be able to understand with the help of these three different like definitions. Okay. I will give you two very simple examples also to understand better. So first of all, what it is saying section 2E defining the term agreement. Okay. What is agreement? Every promise and every set of promises, right? So it may be one single promise also. If I tell you that, okay, fine, what I will do is that I will go out for a movie with you. That is what? One single promise that I'm making, right? Or it may be a set of promises. I'm saying that, okay, fine, we will go and watch this particular movie. Then we will also go for shopping. Now, what is it? There are two different promises, right? So it may be one single promise or a set of promises forming consideration for each other. Now, what is consideration? I want to go out for that movie and also I want to go for shopping, right? But I want someone to go along with me. So what is consideration for me? For me, consideration is that I have someone else also who would go with me, right? So that is consideration for me, right? That is for what I'm doing my part. For you, what is consideration? Maybe you were also, like bored at home, you also wanted to go out. So what is consideration is that you are also getting a chance to go out for some time, right? So what is consideration here is both of us are getting something, and because of which we are making one single promise or a set of promises. So that makes it an agreement, right? It may be any simple thing or any complicated thing, anything, right? It would become an agreement. So what is agreement? One single promise or a set of promises. Why are we making those promises? Because there is some sort of a consideration, right? Some sort of a thing that we are getting out of it, some benefit. It may be some like maybe we were bored at home, we were not meeting anyone, so we, like I felt that okay fine, I would feel better if I go and meet someone, so I am going out. That also may be consideration. Consideration may be anything for which I'm doing my part of contract. It should not be something that like we can feel or we can see or something. It may be anything, right? So what is agreement? Basically any promise or a set of promises that we are performing for some sort of a consideration. It may be as simple as going out for a movie or agreeing to go out for a movie. Okay, so this part is clear, right? What is an agreement?
Yes, ma'am.
So promise or promises between two persons and a consideration should be there. Next is void agreement. What is void agreement? An agreement not enforceable by law is said to be void. What is contract? An agreement enforceable by law is a contract. Now, what is this term enforceable by law? They are not just saying enforceable, right? What they are saying is enforceable by law. That means enforceable in the court of law. It's not simple enforcement. I am enforcing a contract, I am enforcing a promise. That is not what they are meaning, right? They are saying enforceable by law. That means I should be able to approach the court for violation of the contract. So that court helps me, like fulfill that part of contract. Only if I can go to the court for fulfillment of that contract, it would become a contract. If I cannot go to court, it will become an agreement. So can I go to court saying that, like you agreed to go out for a movie with me and now you are not going? Can I go to the court?
No, ma'am.
I cannot go to the court. So what is it? What kind of promise is that? It is the void agreement, right? So when I told you that I will go out for a movie and also we will go for shopping, that is what? That is an agreement for violation of which I cannot go to the court. Now, what is an agreement? Take for example, I made a promise that, okay, fine, like maybe I'm providing some sort of a service. I'm writing content for you. Okay, I'm like a content writer. What I'm saying is that I will write like 50 different content for you and I will provide that. We made a like understanding and everything. Later on, what I'm doing is that I'm not providing you the content within that specified time. Can you approach the court for violation of that? For violation of that, if I'm like agreeing that I will provide this certain type of service, I will write content for you, I will provide it within 1 month and I'm not giving it within that specified time, can you approach the court?
Ma'am, if it is contractual, we can, I think.
Yeah, if it is contractual, we can. So that is what? That is going to the court, right? Enforceable by law. So when I'm making such kind of a promise and you can go to the court, then it becomes a contract. So when it becomes a contract, when it is enforceable by law. But when it is not enforceable by law, then it is not a contract. So does it mean that all the, like void agreements that we have are not enforceable, or can we enforce it in some way? Void agreements, can we enforce it in some way other than approaching the court?
Ma'am, like outside court settlement, are you talking?
It may be anything.
Ma'am, I think it should be mentioned in the agreement earlier that they want to settle through judicial procedure or outside the court settlement, going for ADR or something. In that case, I think yes.
See, ADR and all also we can say that, like they are taking help and, like enforcing by law only, because in ADR also if an order comes, that would become, like binding or things like that. So when I'm saying, is it enforceable in some other way rather than going to the court of law, that means within my own means, can I enforce it? Take for example, I'm, like you made a promise that you will go out for a movie with me and then we will go out for shopping. What happens is that I have come here like very recently, I don't know any places, I don't know anything, I don't know anyone. So what I can do is that later on you said that, okay, fine, I'm not going, I'm busy. What I can do is that I can try to convince you, right? Even though I cannot go to the court saying that, like she agreed to go out for a movie, now she is not going. I cannot go to court. But what I can do is that I can try to convince you, right? I can try to say that, okay, fine, see, I don't know anyone anyways, I don't know any places, so maybe you should go with me. I already planned for it, or things like that. Maybe you will get convinced and you will go with me. So that is what I am trying to enforce it within my means, but I'm not approaching legal, like for legal help, right? Under law, I cannot, like enforce it, but within my own means, I can still try to make you perform your part, right? So that is what they have mentioned. An agreement not enforceable by law. That means I cannot approach the court for enforcement of it, but within my own means, if I can somehow try to convince, convince you, then I can obviously, like do it. So you should remember that for void agreements, they have mentioned, what they have mentioned is enforceable by law. It is not enforceable by law. In case of contracts also, it is enforceable by law. So they are only mentioning about it. But in case of void agreements also, maybe we would be, free to try our own means. We can try to convince the other person and then accordingly get the contract performed. So these are the three different, definitions that you should be remembering. Is this part clear, like difference between a contract and agreement, or you want some more examples for it? Is this part clear?
Yes, ma'am.
Okay, others, is this part clear? Everyone is so silent. Is this part clear? You can tell.
Ma'am, can you give one more example if you don't mind?
Okay. So take for example, in case of agreement, what happens? It can be anything, right? Take for example, take for example, I have a, I have a kid. Okay, what I'm asking my kid is to, after coming from school, you should complete your homework. Then only you should go out to play. What he did is that he also agreed. Okay, fine, I will complete my homework. Then only I would go out to play. The next moment I left from the room, what he is doing is that he just went out to play. Now, in that case, what he did is that he made a promise, right? He made a promise that I will finish my homework, then only I would go out to play. That is what? That is an agreement that he made. But the next moment, what he is doing is that he's violating that, right? Before completing his homework, he is going out to play. Now, can I go to court and say that, okay, fine, my son did this thing. He agreed to perform this part of contract. Now he is not doing it. Can I go to the court for violation of this thing, this promise?
No, ma'am.
I cannot go to the court, right? So that means what? It is void, right? I cannot go to the court. It is not a contract. But do I, like I have other means, right? What I can do is that I can just go to the park, take him, like bring him back to home, and I can ask him to perform, like complete his homework. I can do that, right? So what is it? Within my own means, I can still enforce that particular promise, right? But what I cannot do is that I cannot go to the court to enforce it. So that is what it is. So in case, so it would be a void, like void agreement, that my son was saying that I would complete my homework, then I would go out to play. That is what? That is a void agreement. But when I'm saying something that, like would be legally binding on me, if I'm saying that, okay, fine, like I will be, maybe I will be providing this particular service, or maybe I'm, like you have ordered something online, okay, you have ordered something from Amazon, you made the payment and everything, now they are not delivering. So you can approach the court, right? You can say that either you deliver that product to me or you return the amount back to me, right? So what is that? That is something that you can enforce, like enforce with the help of law, right? So that would be a contract. Whatever you can enforce with the help of law, that will be a contract. Whatever you cannot like enforce by law, that will be a void agreement. So a son making a promise that I will finish my homework, then only I will go out to play, that will be void. But one person taking money and promising that I will deliver this certain, like product to you, not doing it, it will be a contract. So basically, in case of contract, we are having this willingness to create a legal relationship, right? Take for example, like in your family, someone might say that, okay, fine, maybe, like you should try to wake up early in the morning. If you do, maybe, like I will prepare good breakfast for you. So if your mother is saying that, okay, fine, you should try to, like wake up early in the morning. If you do, I will prepare good breakfast for you every single day. Maybe the next moment she won't do it. Can you go to the court filing a case against her? You cannot. Why? Because there was no intention to create legal relationship, right? She was not interested to create a legal relationship. That is something, some just random promise that she made. So those are considered as contracts of social nature. So those are just basically promises that we cannot enforce in the court of law. You may just say that, okay, fine, like I'm saying that, okay, fine, can you come to my place for dinner? You also said, okay, fine, I will come. I prepared food and everything. Next moment, you are not coming. You said that, okay, fine, I'm not feeling like coming. Can I go to the court? I cannot go to the court. So those would be what? Those would be void agreements. You are making a promise, but later on you are not following it, and I cannot enforce it by law. I cannot go to the court for violation of it. But in case of contract, we have an intention to create a legal relationship, and if it is being violated, we can approach the court. So basic thing that you should remember is that part only. Somewhere we can approach the court, somewhere we cannot approach the court. But when I say cannot enforce by law, it again means that we have other means also. We can still try to convince the other person to perform his part. Just that legally we do not have a right to go to the court and file a case. So is this part clear? Difference between these three things?
Yes, ma'am.
Anyone, any confusion you can say, because it will help you understand the remaining concepts, right? So this definition part you should be very clear. So any confusion anyone is having, you can tell me. Is it clear, others?
Yes, ma'am.
Yeah, I'm clear.
Okay. So now after reading these like three different definitions, what we have come to know is that agreements can be of two different types, right? What are these two different types? Something which are enforceable by law. That means when these are violated, we can go to the court. And these are called as contracts, right? There are some types of agreements which are not enforceable by law. That means we cannot go to the court for violation of it, and those would be considered as void agreement. But even though we cannot go to the court, within our own means, we can still try to convince the person and all of that. So you can remember that agreements are of two different types. One is enforceable by law. We can go to the court for its violation. Those would be called as contracts. Something where we cannot go to the court, those would be called as void agreements. Now, this is a table that will help you understand again the difference between agreement and contract. So what is agreement? Agreement is offer and its acceptance. That means I'm making an offer. Would you like to go out for a movie with me? That is what an offer. You are saying that, okay, fine, I don't mind. That is what you are accepting it. So offer and acceptance will make it an agreement. Okay. So for agreement, we need two different things, offer and its acceptance. Second is contract. What is contract? We need agreement. So what is agreement? Offer plus acceptance, right? So we need agreement and its enforceability to constitute a contract. That means we need an offer, its acceptance, plus it should be legally enforceable. Only then it will become a contract. So this thing you can remember, offer plus acceptance, agreement. Agreement plus its enforceability becomes a contract. So for contract, we need one more additional thing, that is enforceability by under law. Next difference is every agreement may not be a contract, but all contracts are agreements. Why all contracts are agreements? Because in every single contract, we have an offer and its acceptance, right? But for all the agreements, we do not have its enforceability. Some of the promises, some of the offers and acceptance are not enforceable by law. You accepting a dinner invitation, I cannot enforce it in court of law. You accepting to go out for a movie with me, later on refusing, I cannot go to court of law. Someone saying I'm, I'm completing my homework and then I would go out to play, later on not doing, I cannot approach the court of law for violation of it. So it is said that every agreement may not be a contract, but all contracts will be agreement. If there is a contract, there has to be an offer plus its acceptance. So these two differences, is it clear? Difference between agreement and contract?
Yes, ma'am.
Yes, ma'am.
Okay, third is an agreement may not create legal obligation, right? If you are accepting a dinner invitation, if you are saying I will go out for a movie with you, it is not creating a legal obligation, right? It may be something that, like some kind of promises that we make every single day with our friends, right? But every single time we do not like fulfill it, right? We may make, lot of plans to go out somewhere, something, but later on we may, like not fulfill it. What we are not having is that we are not having a legal obligation. We are not having an intention to create a legal relationship. But in case of contract, it necessarily creates a legal obligation between the parties, and they should fulfill it. Otherwise, they will have to face the consequences of it. Agreement is not concluded or binding contract in all cases, but contract is concluded and binding on all the concerned parties. So whatever terms and conditions are there in a particular contract, we should fulfill all those things. Otherwise, we will have to face the consequences. But in case of agreement, all of that is not, like binding. If I am saying that, okay, fine, I am, like accepting your dinner invitation and I will reach your place at 8 o'clock sharp, and also, like I will take this friend of mine also along with me. What if I do not reach your place at 8 o'clock? If I reach there at 10 o'clock only, and I also do not, like bring that other friend, you cannot approach the court, right? So in case of agreement, it's not like concluded and binding in all the cases, but in case of contract, everything should be fulfilled. If I'm making a promise that I will write 50 content for you and I will deliver it within 1 month, and it will be, like of these and that, like format I would provide you, I should fulfill all those different conditions, right? So it is what? It is concluded and binding. Whatever terms and conditions are there, I should fulfill all of those terms and conditions, because it is legally binding on me. Otherwise, I will have to face the consequences. So is this part clear? What is the difference between a contract and agreement?
Yes, ma'am.
So now this thing you should remember, that all contracts are agreements, but all agreements are not contract. Why? Because some of them will be void, where we cannot approach the court for violation of it. Okay, so one, like simple thing that you can remember is, so you can just remember what is this? This is an agreement, right? So agreement is what? Agreement is like a bigger thing, right? Under this, agreement is what? Agreement is like a broader term. Under this, there are contracts. Now what happens? All contracts, right? All contracts are agreements, right? Because this entire contract thing is coming under agreement, right? So all contracts are agreements, but all agreements are not contracts, right? This outer part would be what? Those would be void, right? Any promise that we are making, we cannot approach the court. What will be those? Those will be void. So agreement is a broader term, and contract is only like a part of agreements, right? So you should remember that all agreements may not be contracts, but all contracts are agreements. You can just remember this particular like drawing. It will help you remember this sentence also. Otherwise, sometimes it may become confusing. Is it that all contracts are agreements or all agreements are contracts? What is it? It may become confusing. You can just simply remember this thing, that agreement is a broader term under which some would be contracts, for violation of which we can approach the court, and then we can like do accordingly. So is this part clear? Anyone having any confusion until this part? You can tell me if you want any part to be repeated. Anyone, any doubts? Is this part clear?
Yes, ma'am.
Others?
Yes, ma'am. It's clear.
Now another important thing that we will study, after that we will move with the like essentials and everything. So now we know that there will be like an offer, there will be acceptance. Offer and acceptance we are anyways going to study in detail, but I'm just assuming that you all know, right, what is offer, what is acceptance, and all of that. Now a contract, right, or an agreement for that matter, starts with an offer, right? There should be an offer. After that, only the other steps would come, right? So what is the first step that we need is that we need an offer. So what happens when an offer is being made? If I'm making an offer to you, what will happen in that case? If I'm making an offer to you, take for example, I'm making an offer to you, would you like to study Indian Contract Act from me? What is that? That is an offer. Now, what options do you have? If I'm making an offer to you, what options do you have?
To accept or to reject it.
Yeah, you have the option of accepting or rejecting the offer, right? So in case you are rejecting it, that means it would lead to no contract, right? If I'm making you an offer, would you like to study Indian Contract Act from me, and you are like straight away rejecting it, you are saying that no, then in that case what happens? There is no question of contract, right? So what happens is that if there is an offer is being rejected, then there will be no contract, right? There will be no question of formation of any sort of contract. But in case you are accepting, right, in that also you have two options. What are these two options that you have? What kind of acceptance you can give?
With condition and like accepting it directly.
Yeah, any example? What is with condition?
Like the earlier example situation which you gave, like only if you are gonna do both the teaching and MCQ, then this is the condition. And if I am agreeing what you are saying, then I don't think there is any kind of conditions.
Yeah, right. So if I'm just saying that, okay, fine, would you like to study Indian Contract Act? I'm not saying about MCQ part anything, okay? So I'm just saying, would you like to study Indian Contract Act from me? So in that case, you have two ways of accepting it. You can either say that, okay, fine, I will learn Indian Contract Act from you. That is what? That is unconditional acceptance. That means whatever I'm saying in whatever format, you are accepting to it as it is, right? So whatever things I have mentioned, you are accepting to it totally, right? You are not putting any other condition or anything. In that case, what happens? It would lead to formation of a contract, right? I made a offer and you accepted that particular offer. So that becomes a contract. But in case you are putting some other conditions, I just told you that I want to teach Indian Contract Act. I did not mention anything about MCQ part. What you are saying is that, okay, fine, I can learn Indian Contract Act, but only if you also discuss MCQs. In that case, what you are doing is that you are putting a condition, right? So I did not mention it in my offer, but you are making an additional like point or additional clause in it. What is that? That is conditional acceptance. So what happens in case of conditional acceptance? If you are putting a condition, that does not mean you are accepting it, right? What you are doing is that you are making a counter offer. Rather than accepting my offer, you are making a new kind of an offer and you are giving it to me. So what is that? It is called as counter offer by the offeree, right? You are the other person. So what you are doing is that you are making a counter offer to me. Then again, we would, like go back to that same stage of offer. Now I have two options. I can either say that, okay, fine, I will, like discuss MCQs also, contracts also, I accept it. Or I may say that, oh, no, I don't want to discuss MCQs. So no, I don't want to accept it, right? So when you are making a counter offer again, I have two options. I can accept it, I can reject it. So only in case you are accepting it unconditionally, right? You are saying that, okay, fine, I don't mind, like learning Indian Contract Act. Only in that case, it would lead to formation of a contract. But if you are putting another condition to it, then what happens? It would lead to a counter offer. In case you are making a counter offer, I have the option of accepting or rejecting. If counter offer is not accepted, if I am saying that I don't want to discuss MCQ, so no, we don't want to like proceed with this contract, then what happens again? There will be no contract between us. But in case this counter offer is accepted unconditionally, then it will lead to formation of a contract between us. So is this part clear? Like a simple thing, offer, counter offer, what it is? Is this chart clear?
Ma'am, I'm confused. That counter offer is that only, there is one term, no, like when both are saying the opposite thing at the same time. What we call that, ma'am? I'm just not.
Both are saying?
like there was a case law, like what was that?
Like both the persons should, like agree to the same thing in the same sense.
Yeah, but there was a case, I'm not getting the case law, where a person was like, I am agreeing to sell my scooter for so and so price. So the person again says that, okay, for this price, I want to take your scooter. So basically, they are making same consideration, but it's a cross. So is it that only cross offer or counter offer?
Like they are talking about two different scooters, or what is it?
No, one is saying that I want to sell, and the other is saying I want to purchase on the same price. But at the same time, as it was through postcard, so A's postcard went to B, B's postcard went to A. So the term was same, but they both, proposed to each other. So I think that a contract was not enforced. I'm just not getting.
No, like you are saying that at the same time they both made same kind of offers to each other.
Yes, ma'am.
Okay, that is not counter offer. That is not counter. It's like same type of offer you both are making. So that is not counter. For counter offer is I'm making an offer. You heard that offer, then you are putting some conditions to it. That is only counter offer. In that case, it would be like two persons are giving same type of offer. So that would not mean that, like you are accepting to it. You are just making the offer. Then again, the entire process has to be fulfilled to make the persons like legally, bound under this thing. So counter offer, you can just remember whatever I am saying, you are not accepting it as it is. You are putting certain other conditions and you are giving me another offer. At the same time, making same kind of offer because of coincidence, that is not counter offer. It is you know about my offer, then you are putting certain other conditions to it.
Okay.
Yeah. So if you can, you can look for the case law also. We can discuss that also while discussing this offer thing.
I'll let you know in the next class, ma'am.
Yeah, sure. So this part is like basically offer and acceptance. So when I'm making an offer, you should accept to it totally without any conditions. Then only it will lead to formation of a contract. In case you are putting certain other conditions, again, it depends whether I want to accept those conditions or not, right? And in case you are rejecting, obviously there is no contract between both of us. Okay, so is this part clear? Anyone having any question, any doubt or anything? Anyone? Neha, Mamta, you guys are very silent. Is this part clear?
Yes, ma'am.
Okay. Fine. Okay, so there are some questions that we will try to see. So whatever topic we discuss, we will also try to see MCQs, some MCQs for that part. So you can try to answer these questions. When the Indian Contract Act came into force, first question. Okay, so first question is when Indian Contract Act came into force. What will be the answer for this?
September 1870.
1st September 18.
1st September.
Yeah, so it is 1st of September 1872. Yeah. So whenever you are answering these type of questions, right, you should not just look at the, date and month. You should also look at the year. Sometimes they might just give, 1872, 72, 72. In between one would be 71. So you should see that as well, the complete thing like year and everything. So Indian Contract Act came into force on 1st of September 1872. When it was enacted?
25th of April 1872.
25th of April 1872. So these two dates you try to remember, okay? And not just for Indian Contract Act, for any legislation that you are reading, these two are important. Next is proposal is defined under which section of the Indian Contract Act?
Section 2A.
2A, ma'am.
Yeah, it is section 2A that defines a proposal or an offer. Next question.
A, promise.
Promise.
A person making a proposal is called a promisor. Which section defines promisor?
2C.
Yeah. So it is promisor 2C. So who is making the proposal is promisor, who is giving acceptance is promisee. Next is question number 5. Which of the following is correct mentioned? An agreement not. Which one?
Void contract. Void.
Yeah, it will be void, right?
But a
It is
contract.
not
Contract.
contract. Yeah, so you should see that also. So it will not be contract, right? In that case, it will be an agreement because it is enforceability we need for a contract, right? So it will be void agreement. So third one will be so it is void agreement. So which section is it?
Two.
2G.
2G.
2G, ma'am.
Or void, it is 2G. Yeah. Next is
Person who makes proposal.
void agreement. Okay, so which of the following is called a promisee?
Anyone making a proposal, ma'am? So, ma'am, it's saying that which of the following can be called a promise?
Okay, which of the following is called a promise according a person who made a promise, a person to whom proposal is made, a person accepting. It will be promisee. Okay, this
Yes, ma'am.
yeah, it will be promisee. One E is missing. So which one will be
To
the
whom promise is made?
person to whom promise is made? As in, you are making the promise to me. So will I be the promisee?
Yes, ma'am.
The person who accepts the
Proposal.
Yeah.
proposal
So
is the.
yeah. So if I'm making a proposal and you are accepting that proposal, then I am not the promisee, right? You are the promisee. So which one is the correct option?
So to whom the proposal is made. Ma'am, I think
Ma'am?
Yeah.
a person to whom a proposal is made is a promisee.
A person to whom proposal is made.
Because Act says the same, ma'am. It says that the person making a proposal is promisor and the person accepting the proposal is a promisee. So here promise will not be made, here proposal will be made. So person to whom a proposal is made will be a promisee.
See, till the time you are accepting it, you will not be a promisee, right? You should accept it, then only you will become a promisee. So there is one more option that is correct. Which one it will be?
See, the person accepts.
Yeah, it is accepting it. So if I am making a promise, like offer to you, would you like to study Indian Contract Act? I am the promisor, right? I'm just making the offer. Only when you may, accept it, right? You will become a promisee. So the person accepting the proposal will be a promisee. So you should give your acceptance also. Otherwise, it is called like offerer and offeree. When it is in that like offer stage only, you are not accepting to it. So when you accept it, we can say this thing. Okay, next one is like match with A and B. So you should basically match these things with which definition, and then accordingly you should decide.
Option A, ma'am.
Option A.
Proposal is agreement to whom?
So first is proposal. Which section defines proposal?
2A.
It is section 2A, right? So it is matching correctly. So in these type of questions, right, you may not, need to match all the things. If you are very sure that its proposal is defined under section 2A, and it is only one thing where we have it, right? For one only, like one thing where it is matched correctly. So that means A only would be the correct. So even if you do not know the other, like things, even if you do not know where agreement is defined, where promise is defined, where capacity is mentioned, even if you do not know, you can confidently answer it. Why? Because there is only one option where this thing is given correctly. That proposal is the third one, right? A is the third one. So A would be only correct. So B is agreement. Where is agreement thing given? 2E. So accordingly, you can decide this thing. So A only is the correct. So now take for example, out of these like 4 options, right? You don't know this third or like fourth one. So even in that case, you can like try to match all of these 3 and then see which one, is not correct, and accordingly you can decide the thing. Next is consideration is defined under
2D.
Consideration defined under section 2D of the Indian Contract Act. So these type of questions are only like asked. So you can try to remember, you can try to go through this particular like table and also these like things. Okay, somehow you try to remember which section is defining what word. This is like a very common question that is being asked. And also these 2 years, date of when it was enacted, when it came into force. So next thing that we will study is with regard to basic elements. So there are certain basic elements that we need for formation of a valid contract, right? So under these elements only, we will study about different types of things also, that there are certain agreements which are specifically declared as void, who all are competent to contract, how offer will be made, acceptance, communication, and all of that thing we will cover under this only. Okay, so we can just start with the first element. So what is the first thing that we need for formation of a valid contract? First thing that we need, what is like the first step of making a contract?
There should be 2 parties.
Proposal.
Yeah, there should be parties also, and there should be proposal between the two like parties, right? If I am willing to make a contract with you and I'm just like willing in my mind only, I'm thinking that maybe I can like make this type of a contract with you, is that enough? Unless and until you come to know about it, you cannot give your acceptance, right? So what I should do is that I should let you know about my intentions, right? So that is what is called as offer. And also, like after making the offer to you and you are in your mind only thinking that okay, fine, this like this sounds to be a good offer, that is not enough, right? You should give your acceptance and I should know about it. Then only it would lead to a formation of a valid contract. So the first element that we have is an offer and its acceptance we need. So again, for here, like we will study in detail like the definition part and all the other things for this part also. So I'll just start with it, and in next class we will also try to see some like case laws also that will help you understand the things better. So case laws are not like that important also, but it will just help you understand the concept. So for case laws, I don't think much questions are being asked, but still we will discuss some of the important ones. So it is section 2A that defines proposal or an offer. What is it? When one person signifies his assent, like signifies his willingness to do or to abstain from doing anything with a view to obtaining assent of that other to such act or abstinence, it is said to be a proposal. So what is signifying? Signifying means I am letting you know. What am I letting you know about my willingness, right? So if I want to enter into a contract, I am letting you know about my intentions. It may be to do or abstain from doing anything. So what is the difference between to do or and abstain from doing anything? Anyone? Do or abstain from doing anything? Like, do we make any type of contract where we just like promise to abstain from doing anything?
No, ma'am.
We don't. Anyone? Do we make any such kind of like?
Yes, ma'am.
Any?
Certain contracts are there which abstain a person to do something
Okay,
beyond.
like any example?
Ma'am, for example, rent agreement. So there is a like agreement between the landlord and the tenant. So your purpose is to stay there and enjoy the property, but you can't have a construction on that property.
Yeah. Yeah, so good example, right? That in case of rent agreement, what I have the right to stay there and enjoy the property, but I cannot do any sort of construction or anything without permission or approval of the landlord. I cannot, like have a like subtenant, right? I cannot bring some other person and then I can take rent from the other person and then give it to the landlord, right? Those clauses are also mentioned that I cannot do that. So it may be what it is to abstain from doing something I am doing. So sometimes what may happen is that in one single agreement only, there may be certain clauses where I am agreeing to do something, and there may be certain clauses where I am agreeing to abstain from doing something. Okay. Both the things may be there in one single agreement. It may be there. Sometimes there may be two different agreements. In one agreement, I'm agreeing to do certain things, and in one agreement, I'm specifically agreeing not to do certain things. That also might happen. Any example that you can give where I'm just, like making a promise that I will not do these things. There is nothing to do about what I'm doing. Any example of that you can give?
As in, I did not get the situation, ma'am.
See what you are saying, right, with regard to rent agreement, there we have both the two things, right? I am also saying that, okay, fine, I will pay you rent on time, I will do this, do that. So there is also certain clauses where I am agreeing to do something, and also there are certain clauses where I am agreeing not to do something, that I will not do any sort of construction without your permission. So in one single agreement, we have both the things, right? That doing something, not doing something. Sometimes there may be one single agreement where I'm just promising not to do certain things. I'm not promising to do anything under that. Just I'm saying I will not do this, I will not do that, I will not do this. Any example of that kind of agreements that you can give? Where I'm just promising not to do certain things only. Any example? Take for example, I am like providing some sort of a service. Okay, what I'm doing is maybe some kind of legal document I'm preparing. Okay, and you are having like a big company. Now you are like you are working on some kind of a project, and you need to disclose details of those projects to me because you want to get some legal documents being drafted. When you are giving details of that project to me, what you want is that I should not disclose those things to any other party. Otherwise, your rivals may just, like copy that idea and they can start with the work. So in that case, what you can do is that you can make one specific contract that I will not disclose those materials to any third party. When this work is completed, I will like hand over all those information or documents to the person. I will not use those for any other purpose or any other matter. So anyone knows what type of contract those things are called, where I'm just agreeing that, okay, fine, whatever information you are giving, I will not use it for any other purpose. I will not disclose it to any third party or things like that. What kind of agreements are those?
I'm certain kind of, it is like like when you are talking about legal firms, so it will be a attorney and client privilege thing. So they are not supposed to disclose their personal information.
Yeah, and otherwise also if I'm something, like some random kind of service I'm providing, okay, maybe I'm just, like making some sort of drawings for the client. In that case also I'm saying that whatever information you are disclosing to me, I will not disclose it to a third party. What are those?
Example of psychiatrists also, like people go
Yeah.
and but they are not supposed to disclose about them to others.
Yeah, not about to disclose all those information. So that also we can say. So what is that? We are making a non-disclosure agreement, right? That whatever information you are giving, I will not disclose those information. In case you are opening a bank account or things like that, if I go to the bank would not provide me those information. If you are calling any like like this Airtel and Vodafone and all of them, you cannot just call them and ask this number belongs to whom. where this person lives. They would not tell. Why? These are certain kind of, like information that they are getting under, like a certain kind of, like there is a relation between those two persons, and because of that only they are getting, so they would not disclose those. So for that, like non-disclosure agreements also may be there. That is like very common in between like companies, right? So in companies, what they would do, one company is taking some sort of a service from another company, so they will make a non-disclosure agreement for sure, where they would say that whatever we are disclosing to you, you should not disclose it to someone else. So that is like a very common term that is being used. Non-disclosure agreement, that is for sure like companies are making, so that their information is not being, like provided to someone else. So in case of offer, what happens, it may be to do something, right? That I'm like accepting your offer of writing 500 content, that is I'm agreeing to do something. Also, I'm saying that whatever topics you are giving me, I will not disclose those to any person. For what purpose you are asking me to write those things, I will not disclose to any person. That is what not to do something, right? Abstain from doing something. So both the things may be there in case of an offer or proposal. So I'm making an offer to you just because I want to get approval from you that you accept those things. And that is what is an offer or a proposal. So next things we will discuss in next class. So I hope this part is clear. If you have any doubts, any concerns or anything, you can let me know. Or any other things that you want to be discussed or anything, you can let me know. Anyone? Is this part clear?
Yes, ma'am.
Okay. Fine, and so there are some other essentials that we will continue in next class, and also we will see like some important cases also. Okay, so in the meantime, if you are getting like any interesting case or anything that you want to be discussed, that also you can just like tell me in class only that this is the case that we want to discuss. Maybe we can discuss that also in like coming classes. So fine, then I'm ending this class here. We will continue with the other basic elements in next class. Okay.
Okay, ma'am.
Okay then. Thank you.
Thank you, ma'am. Good night.
Yeah, good night.
Thank you, ma'am.
Yeah.